Okay, it's 6 o'clock. Call the, disciplinary subcommittee, July 11, 2024, to order. Guidance for the committee in disciplinary proceed. Roll call.
Okay, so I will. Okay, Mr. Caleb?
Here.
Mr. Zimmer?
Here.
Ms. Gomez?
Here.
Does he indicate that? So we have, okay, all three are present.
Will the board's attorney please explain the procedures and the committee will follow during the disciplinary proceeding this evening?
Yes.
I'm Vicki Selton. I am with the law firm of Von Briesen and Roper, and I will be acting as the hearing officer today. This is a follow-up proceeding to the employees' due process meeting that was held before the full Board of Supervisors on July 1st, 2024, under Wisconsin statute section 19.85 1A, B, F, and G. At the conclusion of the meeting, the board voted unanimously to present the employee with a disciplinary agreement in lieu of termination of employment. The board held that the terms of the disciplinary agreement were non-negotiable and specifically included in their motion that in the event the employee failed to accept the disciplinary agreement, or upon acceptance, if the employee engages in behavior that potentially violates the terms of the agreement, that a 3-person committee consisting of the Human Resources Manager, the board chair, and the Personnel Committee chair was delegated the authority to make a decision as to whether termination/removal from his position was warranted. We are here today because the employee has not signed the disciplinary agreement and has recommended revisions to the agreement contrary to the board's direction. The procedure that we're going to follow tonight is the same as the procedure we followed on July 1st, and Mr. Schultz, you were at that meeting, so I will ask you initially, are you requesting that this meeting be held in open session or closed session?
Steve should be on virtual here, so he's supposed to be on virtual here.
I don't believe there were arrangements made for him to attend virtually. Was there a request to appear virtually?
No, but we do have the link, so, and I don't see anybody else on there.
Did he have the link to?
The link is on.
It's on the agenda.
Okay. It's 6:05. Was he intending to attend?
Yeah, he said he'd be here virtually.
Would you like me to share the invite with him to see if he's having technical problems?
I suppose we could.
Ash, could you pull up his email address?
That's weldriley.com.
Okay.
Or did he message you at all that he can't get in?
He hasn't texted me yet.
Sweld at
Weld Riley.
RILEY.
Yep.
He said,
Is he waiting in the lobby?
he's waiting in the lobby and you guys haven't invited him yet.
But wouldn't be, we haven't invited. We probably have to let them in.
But there's no request to join the meeting anywhere.
He said at Teams, it says when meeting starts, they will let people know I'm waiting.
Here, but I don't think it's mine, is it? It just went off.
So I just tried to join it to see, and I can see him. He is waiting in the lobby. When I joined the link, that was via the agenda that they set up. I know it's different than that, but it says that I'm in the meeting. And it says he's waiting in the lobby. It's waiting for others to join. That's what the link on the agenda says.
Yeah, I don't know why that's not the same though. That's the county board laptop, I don't know what to say.
Do you want me to use? I see Ashley's there.
Can someone just plug their computer in instead of the county board computer?
And there's,
Here, we can plug mine in. I got mine on. Steve, can you hear us? Through my computer? Can you hear us?
Yes.
Okay, hold on. We're gonna switch computers.
he's on this one.
But one of them needs to get plugged in.
Yeah, just get rid of those cords.
Okay. Can you hear us?
I can hear.
Okay.
Steve, is your client requesting that this meeting be open to the public, or is he requesting it be conducted in closed session?
Open.
Okay. All right, so we're in open session. The same hearing procedures will apply as were in effect at the July 1st meeting, the disciplinary meeting. So the purpose of this meeting is for both sides to present information with respect to what has transpired since the July 1st meeting. And so therefore, I'm gonna call upon Ashley Heath from the administration to present any opening statement and to present facts and documents with respect to the position that
I can't see anything, who's in attendance?
we have the three members of the committee. The subcommittee, we have Clerk Connie Meyer, myself, your client, and I don't know who the other two individuals are.
IT Neil Robinson and Carissa Ostenso.
Can you see now?
No? I have a picture of a G, it says Ashley Budis.
Mine shows that picture.
Is it on the?
Well, can you see?
Now I can see.
Okay. All right.
Okay, so thank you. As Attorney Sultan said, my name is Ashley Heath. I'm the administrative coordinator from Rusk County. At a meeting on July 1st, 2024, the full Rusk County Board voted unanimously with one absent to place Gary Schultz, facilities manager, on a last chance agreement. The board was very clear that Mr. Schultz either sign the last chance agreement as it was written, or Mr. Schultz would be ending employment with Rusk County. The board agreed that this last chance agreement was non-negotiable. The board also agreed that they did not want to meet again, which is why this disciplinary subcommittee consisting of the board chair, the personnel chair, and the human resources manager was formed at that July 1st meeting. On July 2nd, 2024, the last chance agreement was presented to Mr. Schultz and Attorney Weld via email from the county's attorney, Vicki Selton. See Exhibit A.
I don't have exhibit A.
You were provided with it, Steve, I forwarded it to you, on July 2nd, so you have it. Same as the one you received from me, it was the proposed last chance agreement that you made revisions to, which will be coming to those documents next. Please
You
proceed.
said that we have 20 minutes. Does the administration get 20 minutes?
They actually have 15, you have 20. Okay, please proceed.
Who set the rules? When did they set the rules? You know, we have no knowledge of what's going on.
There was a letter sent to your client, and it's an exhibit, and if you would let us know when you were gonna be appearing virtually, we would have sent you the exhibits ahead of time. We did not know. Please proceed, miss, let's move forward.
Is it inappropriate to appear virtually? It says by your rules that can't appear virtually.
Yes, but it's common courtesy to let us know that you're gonna appear virtually so we can share documents with you.
And we don't share documents with people that are virtual, do we, Connie?
Okay, on July 3rd, 2024, the last chance agreement was rejected by the employee via a letter emailed to Attorney Selton. This correspondence also included a revised version of the last chance agreement as deemed acceptable to Mr. Schultz. See Exhibit B. In light of Mr. Schultz's refusal to sign the last chance agreement as was authorized by the board on July 1st, 2024, this meeting of the disciplinary subcommittee was noticed. Mr. Schultz was sent a letter via email by HR Manager Goodis on July 3rd, 2024, stating that this meeting would occur and that he would have 20 minutes to speak to why he should not have to sign the last chance agreement as presented by the board. See Exhibit C. On July 10th, 2024, Attorney Weld sent correspondence stating that Mr. Schultz was still not willing to sign the last chance agreement the board authorized, and again sent to Mr. Schultz's version of the last chance agreement that he would be willing to sign. See Exhibit D. Mr. Schultz's action in rejecting the last chance agreement as presented by the Board of Supervisors ultimately results in termination of employment and removal from his position as facilities manager with Rusk County.
Mr. Weld, do you have any questions of Ms. Heath with respect to the administration's position?
Yes, did the board have the last chance agreement in hand on July 1?
I can answer that, no, because it wasn't drafted until July 2nd.
Okay, so the board didn't approve the last chance agreement.
They directed the terms to be included in the last chance agreement, and that's how it was drafted.
The terms were a leave of absence, or sorry, a 2-week suspension, an EAP, and entering into a last chance agreement.
Correct.
It didn't say what the last chance agreement would specifically say because it didn't specifically have that.
Chair Caleb, no, approved it. You approved the last chance.
On July 1?
On July 2nd.
So the board hasn't approved the last chance agreement that you're going to fire Gary for not signing.
They delegated authority to legal counsel to draft it. It was drafted per their instructions, reviewed by the board president or chair, and approved.
Ms. Heath, were you in the board meeting on July 1, the closed session?
I was not present in the closed session.
Okay, so you don't know what the vote was?
Which vote?
The vote to remove Gary from his position.
I am aware what the vote was because of communication with legal counsel, yes.
It says the vote, the memo that I think you included as Exhibit A said the vote to terminate failed by 2 votes.
Where is it?
Verse 9, verse 7.
One where it says that.
That's not in Exhibit A.
Well, the memo that you sent on July 2 at 6:57 a.m. says the board deliberated under 2 hours and voted to and the vote to terminate failed by 2 votes.
It was sent by you. It was sent by you.
It was sent by myself. It was an email from myself to you.
Right, so the vote to terminate was failed by 2 votes, the vote to remove.
Yes, that's listed in Exhibit B.
Right.
Do you have a question?
So the vote to terminate failed by 2 votes, why are we here?
Because in lieu of termination, the board voted and unanimously agreed to offer your client the opportunity to remain employed by signing a last chance agreement. And and if he signed the last chance agreement, if there was any, conclusions made that he may have violated, when he returned to work, if he violates the terms of the last chance agreement, it was to be determined by, Human Resources Manager, Goodis, but then reviewed by the, as part of the 3-person committee, so that wasn't just a 1-person decision.
No, it has to be by statute, a decision of the full board.
That authority was delegated to this disciplinary subcommittee pursuant to state statute that allows, yep,
The statute says to remove a department head who's been appointed by the county board, it has to be done by a 2/3 vote of the full board. You're indicating that it didn't happen?
I'm indicating that as part of the motion, that a decision was made to delegate that authority to a 3-person subcommittee, and that's why we're here today. We can agree to disagree.
Present subcommittee was to approve a last chance agreement that the full board did not see.
It was authorized by the full board. Do you have any other questions?
Ms. Heath, no.
Okay. All right, it's now time for your client to present whatever information you want the subcommittee to consider with respect to this matter. And as indicated in Exhibit C, the July 3rd letter, you have 20 minutes.
Has the committee received our July 10th letter?
Yes, that is Exhibit D.
I would like a packet, a full packet at some point in the future.
I can send it in the morning.
Is that before or after the full board's gonna vote?
Is that a question?
I guess the position that we take is that the full board has to vote somehow. I'm now looking at the chair. Can you focus me back on the committee?
No, that's the camera system. That's how it's set up.
It kinda works on its own.
I think you can.
Okay.
It went back. It went back.
I don't know how to run these.
We've already stipulated who's here, so you know who's here and who's not here.
Well, yeah. Let me state that when Mr. Collett, you were elected chair, and Mr. Zimmer, when you were elected chair of the Personnel Committee, we were optimistic that the county would be moving into a position of fairness. Mr. Zimmer, I heard the start of your meeting at the indicating that you were looking forward to a clean bill of health, a new start with the new committee. And we appreciated that concept and that thought. But this isn't it. This isn't it. What all we know is that in a vote to remove, the full county board voted not to remove. In other words, the supermajority required wasn't met. What you are asking Gary to do is to waive his statutory right to a 2/3 vote. We don't know what happened in that county board meeting, because like Ms. Heath, we weren't invited. We don't know what conditions were imposed. We don't know, in fact, how the committee could, in closed session, take those actions. It should have gone out of closed session and made the decisions to establish a subcommittee, made the decision to establish the rules that the subcommittee was going to be operating under, to establish the authority of the subcommittee, and to establish the membership of the subcommittee. Ms. Gugas has, at the July 10th meeting, stated that she believes Gary should be terminated, should have been terminated. How can she be unbiased? And under the last chance agreement, which was prepared by the county, apparently after the county board meeting, and therefore not approved by the county board, after that meeting, the last chance agreement was established, which says that Ms. Gugas is the person who makes the determination on whether Gary's conduct was appropriate or not. He's already made the decision that he should be fired. She's one of the 3 votes. We're hopeful, Stacy, and we're hopeful, John, that you are not going to be part of this parade of injustice. You're asking Gary to waive his statutory right. And he's not going to do that, on my advice. We've got serious problems in this county. There's turnover like mad. You need to address those concerns. I mean, getting rid of a good employee, an employee who busted his butt, oh, I might get fired for that. Is that like bullshit? Is that gonna get me fired? Is it gonna get Gary fired because his counsel used a swear word? Come on. I don't know what the vote of the county board was. I know, Mr. Caleb, that you had 11 votes in order to become elected chairman, and I suspect that some of those 11 votes are expecting you to vote for Gary's termination. I think that's crazy. The problem we have here is that Gary was lied to from the outset by your predecessors. He has tried, not being a municipal employee, to try to figure out how to fix what he believes was an unfair move. And he hasn't been able to get an answer. As we indicated, we now realize that the county has apparently delegated to Carlson Detman the ability to grade positions. Gary didn't understand that. And he's willing to play the game. Just as Miss Heath did when she moved her $73,000 salary to what, 95, 96, 90, somewhere in 30% anyway. That removed the cap that your predecessors established for Gary, and he's prepared to play the game and go through that process. He's also prepared, as we've indicated in writing, to take a 2-week suspension. He's such a good employee, he has said to your officials that he's willing to use his paid time off, his vacation, because he wants to get back to work. Because he's got work to do and work that can get done in the summertime. That prohibition was taken out of hand. Would the full county board agree that because Gary is willing to take a 2-week suspension, that's enough? I don't know. We weren't at the meeting. It comes down to you two guys. because we know Ashley's gonna vote no. She's already said she voted no. She recommended that we voted no. She shouldn't be part of this committee, period. Your advice, you know, the second part of the problem or program, as we understand it, based on what we received from your council, was that Gary had to go through an EAP. He's already done that once, but he said, okay, I'll do it again. But by the way, by statute, if you're ordering him to do medical tests or medical exams, you gotta pay for it. 10367, that's the statute. You can't force a person to do something and pay for it. You can force him to do it, and he's willing to do it. There's a flaw in your last chance agreement, you need to fix it. The third area is the last chance agreement itself. You're asking Gary to waive his rights under the grievance procedure. Under the grievance procedure, an IHO or impartial hearing officer is in place. And he's in place, frankly, because the legislature said we don't trust municipal government to make fair decisions. We want an impartial hearing officer to make that decision. And by the way, Gary's agreed to that, even though he doesn't have a vote in terms of who's selected as IHO, and even though he'd have to pay. But what he isn't agreeing to is the fact that if Ms. Kupas comes to the committee and says, we got grounds for termination, that IHO has to terminate. Can't make a decision on suspension, can't make a decision on reprimand, it's gotta terminate. That's not right, that's not fair, it's not what the statute calls for, it's inappropriate. This is a sham, and all we are asking you to do is do your job and send it back to the full county board and have a vote. Gary knows that the full county board could terminate him at its pleasure. There's no standard, no just cause standard, no arbitrary and capricious standard. They can terminate him because he's 6 foot tall. They can terminate him because they don't like the shirt he's wearing. It's at his pleasure. But that's what he's entitled to by statute, and that's what he should get. You're asking him to waive his statutory rights, and that's wrong. Gary, do you have anything to add?
I think you covered it very well.
I'm just gonna address two points, Steve, that you brought up. With respect to what you perceive as flaws in the last chance agreement. If you look at paragraph 2, that's the paragraph that pertains to the EAP referral, the mandatory referral. It indicates in the, second sentence that the employee is only responsible for those costs associated with his participation in the EAP program that are not covered by the county, the program, or the employee's health insurance. So it's not all at his expense, it's only those expenses or costs that are billed outside of what is covered by the county's normal insurance programs.
He doesn't take county insurance.
And then
And that doesn't meet the statutory requirement. In other words, you're going beyond the statute.
And then with respect to your statement that, or perception that he is being asked to waive his statutory grievance rights, the statutory grievance procedure in paragraph 8, it does reference the fact that he would have every right to file a grievance under the statutory grievance procedure, but the issue before the IHO would be whether to sustain the decision that was made, which is what the grievance procedure already says, is that the IHO is only given the authority to determine if the decision made by the board or the committee is, I don't think it's arbitrary and capricious, but it's basically a standard like that it's, the IHO has no authority to void a termination and impose a suspension or some other disciplinary action. It's only to make a determination as to whether there's a rational basis for the decision made by the board or the committee, so. Do any board members have questions, or committee members have questions of, Mr. Weld or his client? Does county administration have any closing remarks that they wanna make?
I would just say in closing, that again, Mr. Schultz's action in rejecting the last chance agreement as authorized and presented by the Board of Supervisors ultimately results in termination of employment and removal from his position as facilities manager with the county. Thank you.
Attorney Weld, anything else you wanna make, any statements in closing?
I think that we're asking Stacy and John to step up and do what the statute calls for, which is that the only people who can fire Gary are the full county board by a 2/3 vote. He's not waiving his statutory right, and that's what you're asking him to do. And the county board, I think, probably violated the open meetings law on July 1 by taking those actions in closed session. We don't know what the county board did. We don't know what the county vote was. We asked your council what the breakdown of the vote was. We haven't gotten that yet. Problem is the counties, not Gary. And we're hopeful that you'll see that Gary, through this whole process, you'll see that Gary is a decent employee, a good employee. All of his employees came to the meeting on his behalf, at risk. They risked appearing before the council. Several of the board members have been opposed to Bugsy. Everybody knows that. I know that. That's crazy. But Gary stood up on his behalf. His employees are standing up on his behalf. You've got a good employee. You're foolish to get rid of him.
Anything else before the board deliberates? Or the committee, I'm sorry, deliberates? Alright. Does someone wanna make the motion to go into closed session to deliberate?
Second.
Do you wanna read the statute?
This one here.
Yes.
I hereby move to adjourn into closed session for the purpose to deliberating regarding the purpose of discipline as permitted by Wisconsin Stats 19.85 para 1 para A, and for the purpose of conferring with the board's legal counsel as permitted by Wisconsin Stats section 19.85 para 1 para G.
Who's going into closed session?
I will second that.
Yes.
Ms. Goodens?
Yes.
Myself, yes.
Yes.
We're not going into closed session.
Steve, it'll just be, the three members of the committee and myself and the clerk.
Why would the clerk go?
Because it's her official duty as clerk to take minutes of a closed session,
Why doesn't it delegate to you?
because I'm assisting and I'm busy.
Well, all I can say is this is part of the problem the county's got, Stacy and John. I mean, it's 2, 3, or 4